We've been talking about disruption, AI. That's our theme, honorable members of the panel. And we want to look at the current state of affairs. We want to identify challenges. I just want to demystify for the judges here, we're not going to go into technical language here. We're just going to talk about relatable issues as far as AI and the adoption of AI in our courts, as far as you're concerned, your own experience, and lessons you can share or experiences that you can share with our audience. Remembering that our audience is made up of different professionals. We have lawyers, we have techies, we have people in regulation, we have policy think tanks. I mean, you've listened to some of the presentations. So it's a mixed bag, but the overall idea is something we can all relate with. So having done the introductions, we can go straight into the questions, where I want to start with the Honorable Ntaba. And in your experience, maybe you can give us a backdrop of Malawi and what has been the approach in implementing the digital court systems. Keep it brief. And, what were the initial challenges that you encountered as a user?
I like counsel telling me to keep it brief.
I told you I'd take this
What protections does she have? Or maybe there'll be mitigation, since there are a couple of people. We'll see. Maybe you might get away with it. Greetings from the warm heart of Africa, Malawi. Next time, I'm going to do my tourism bit. I live in a beautiful city called Zomba. It's got a beautiful mountain, and on top of the mountain is a beautiful dam with amazing spring water. So if you ever visit Malawi, come join me in Zomba for a cup of coffee and beautiful fruits. You say Karibu, eh? Karibu to Malawi. In terms of Malawi, where we are at right now, we used to have a case management system that was developed around 2013 thereabouts, but then it became obsolete because it wasn't user-friendly. It was developed by an Eastern Europe developer who didn't give us rights to change a lot of things. So there was a lot of hullabaloo about the use of it. And also, the last thing was that it wasn't user-friendly to us as judges alone, because there were so many steps in the system that had been missed. Because, I don't know, as the lady who had come, I was doing on AI and judiciaries, the development requires that even us as end users be part of the development, so that you understand what steps, because there's always nuances within the system that needs to come through. So that's where we're at. So the case management system is not working. What's working is the e-courts. So the e-courts are what we are now piloting more, whether it's at the High Court level, the Supreme Court level, and now we're also doing a pilot with UNDP at the magistracy level, especially with the remote areas. We still have a hybrid system, so we still do case management through electronic filing, but a lot more still with paper. So that's where we're at in terms of Malawi.
Okay.
Yeah.
Thank you.
So that's what I could say.
Thank you.
Yeah.
On to you, Honorable Justice Aisha Sinda. In your view, what are your current regulations or legal frameworks in Tanzania sufficient to address the technology-related disputes, or do you feel there's a need for specialized courts in Tanzania?
Thank you, Maria, for the question. Well, in relation to tech-related disputes, there are so far not much in relation to ICT and AI. However, we have had some disputes in relation to intellectual property rights, which are more complicated. And in this case, the judiciary of Tanzania has partnered with the World Intellectual Property Organization to provide specialized training to judges and magistrates on such aspects. And you have asked me if I think there is a need to have specialized courts. In my view, so far we have specialized courts like labor, employment, family courts, land, and I think there is no need to add more specialized courts because we have a limited number of judges who are specialized in such areas. And also, we have talked about financial issues facing the judiciary. In my opinion, it would be great for judges and magistrates to specialize, to put more efforts in specializing in tech-related cases. And in such instance, it means the principal judge, if he admits a case which is tech-related, he can directly assign it to a respective judge who is specialized in such area. And in terms of the laws, so far we have laws in relation to data protection and privacy, consumer protection, IP rights, and not much has been done in relation to AI. And as we've discussed throughout this conference, I believe there is a need to integrate AI as well in our laws. Thank you.
Thank you very much. And I agree with you, Justice Cinda, that your approach about adoption of technology across the board, it doesn't matter which division, is the way to go. Over to you, Justice Visram. Would you, based on your experience now at the division, at the Milimani Civil Division, and I'm sure you've handled cases where electronic evidence is submitted, do you feel that the authentication, in terms of the courts, from the court's perspective, authenticating this kind of evidence, do you think that the courts are sufficiently equipped as a division? Do you feel that there's room for improvement, and what do you feel that could be?
Thank you very much, Maria, for your question. I will try to speak in terms that are not very technical so that our audience is able to understand whichever background you might come from. The electronic evidence and the digital evidence that comes to the court is dealt with by the Evidence Act. Now, our Evidence Act actually has substantive provisions on how we admit and what sort of weight we assign to electronic and digital evidence. For the lawyers here, you will be familiar with Section 78 and Section 104 to 106. Those particular sections say that you can have electronic evidence, whether it's WhatsApp messages, whether they're screenshots, whether it's CCTV footage, whatever it might be, is admissible in court. So there is a judicial openness to digital information, and there is a judicial openness to the increasing amount of evidence that will be brought to the court arising from social media and WhatsApp and other platforms of that nature. What's important to us as a judiciary, though, is that we can ensure that there is due process, there is fairness, and that that evidence is reliable. So how do we do that? What we do is we ensure that the evidence has a certificate, and that certificate has to state where the evidence came from, how the evidence was produced. It has to have a signature of the person who was responsible for handling the device. So if, for example, you want to produce WhatsApp messages in court, you have to say the phone it came from. You have to say how it was extracted, where it was extracted from, and you have to show that there's a record of extraction and a signature of the person who handled the device. The idea is that there should be a chain of custody in terms of the information that comes to us. Now, what does that mean? That means we want to know that the record hasn't been tampered with. We want to know that it hasn't been manipulated. We want to know that someone hasn't picked up your message to your friend, deleted a few words, and then said, this message is clear implication of corruption on the part of that individual, and you can see it. Because we all know now that AI can be used to tamper and manipulate. So the Evidence Act provides substantively for the provisions that have to be complied with when producing that evidence in court. But what we look for as a court is to make sure that it's reliable, and then we give it appropriate weight or probative value, as lawyers might call it, depending on all those factors, and we assess them bit by bit. To give you an example, there is a case called Alex Owiti versus Republic of Kenya, where the High Court said that WhatsApp messages that were being used by the prosecution to implicate the accused in the offense of a murder could not be admissible. Why? Because there was no certificate produced under Section 106. It was not clear where the messages had come from, who had extracted them, who was responsible for the phone, and the phone itself hadn't been produced. So those kinds of safeguards will ensure that you are also given a fair trial when the prosecution starts producing that kind of information. At the same time, the judiciary is aware that we are living in a digital age, so we want to be open to that kind of information. I think that's a good starting point. I would say in terms of training, there's an absolute need for more training in this area.
Yeah.
I think judges would perhaps benefit from training not just on the applicable principles arising out of the Evidence Act, but also training on the underlying technology. So it would be good, for example, for us to have an opportunity where an expert says, this is how we extract messages from a phone, and give us a hands-on detailed account of how it's extracted, how it's stored, and how it's preserved. Because I think beyond really the law, we need to understand the technology. So I think that's an area for the Kenya Judicial Academy, KJA, or the JTI, to look at. And I think that's an area where we can engage with experts in the audience and members of law tech who can come forward and say that this is an area we can collaborate with the judiciary on. I'll stop there because I'm sure there's more on this topic. Thank you.
Absolutely. Thank you very much. And I like the way you've just ended with a collaboration and a training. And that's absolutely a great way forward. We will definitely take that into consideration. Now, on to you, Justice Kendagor, and just building up from what Justice Visram is talking about. In your experience, we've known you to do a lot of work in mediation. And I just want to ask you about adaptability of the technology. Like, there are things we don't ordinarily consider or now seem very ordinary to practitioners, like service through WhatsApp, and Justice Visram has just mentioned it. Type proceedings can now be transcribed through AI. It's becoming easier. In your experience, having come from the manual system and now adopting some form of technology, what do you feel is working for you in terms of maybe some tools, and what can we do better from the judiciary's perspective?
Thank you very much, Maria. I think the biggest lesson about technology is just to be dynamic and just transiting into the future along with the technology. So a lot in terms of, I think the technology that we are employing, all of it has been very useful. Coming from an interaction where the information that we have is information that is also consumed by our stakeholders, I would look at it that we are at par at least with what is required. But there's a lot more that still needs to be done, especially conversations about not just being able to use the technology, but conversations about issues like infrastructure, what Judge has just mentioned, the issue of training about that technology and just understanding it across. Because even as much as we talk about the uptake of technology, the uptake of having data that can speak, not just information, it's not about the sensitization and the training of the judiciary only, but also falling back to what is happening with the stakeholders. We have had instances where in interaction of cases that are related with technology, you almost feel like the advocates and the parties are just leaving it up to you, just do what you need to do. So if we were to focus then on the issue of sensitization and the understanding of technology, not just from the level of the decision maker, but from the level of the council and parties who are generally participating in it. The other issue in terms of, I think, I don't know if it fits into the conversation about algorithms and what is it that we put into consideration and what the stakeholders put into consideration. It depends on the nature of outcome that you really want out of the technology that you are employing. So like, for example, for the judiciary, our outputs may not necessarily be the same outputs like what the advocates might want or what the parties may want. So I would look at it more in the need of the continuous engagement, making it possible to have those interactions that even the external stakeholders can interact with the system and give us feedback in terms of what is it that they would like to see out of the technology that we are employing. And then for us to even get back to them and that if you were to feed this kind of information, if you were to feed the information in a particular style, if you were to be accurate with the inputs that are put, then it would also help us to have this kind of output. So I think continuous interactions to just look at what are the different areas that we are all looking to have out of this, and what do we need to do to be able to achieve those kind of outcomes.
Thank you very much. Thank you. And now over to you, Honorable Justice Ablo. In Ghana, like in all other jurisdictions, you have case management systems, and we would want to hear your views on the adoption of what case management system looks like in Ghana, and what electronic case management looks like for you, and the impact of that in the administration of your court.
Thank you very much for the question. So in Ghana, the case management system is not electronically available in all the courts. A few years ago, we had a judicial service project to migrate almost everything we do online. We called it the e-justice system. Unfortunately, as one of the panelists has already mentioned, the system was not developed in Ghana. It was a European company that developed it. So the usual challenges you have that is not consistent with the practical situation in Ghana became apparent. It was then a decision to deploy it only in Accra. As it is now, all you can do is to have a case number assigned to what you are trying to do online. The rest is all going to be paper. Beyond Accra, almost everything is manual. So the challenges we are having in Accra has to do with, are we going to be practical about our wish and aspiration to go technologically inclined? How are we going to do it? And the answer now amongst the fraternity is, let us develop our own to be able to make it more functional, access it as and when, evaluate it, and then also do updates to it. When it comes to electronic evidence, we rely mostly on the Evidence Act, we rely on the Electronic Transactions Act, we rely on the Lands Act, which was passed in 2020 because it made some amendments to the Electronic Transactions Act. With the Electronic Transactions Act, there are specific agreements or documents that would be admitted in court in the electronic form. Land documents were not supposed to be part of it. So if you have a case bordering on land. You are relying on land title and you say you want to rely on the electronic version. No, it will not be done. You cannot sign a land document electronically. But now with the Lands Act, looking at the challenges that we've had with paper, it has now reversed that provision and made it admissible, even if it is done electronically. We are seeing advancements in terms of the knowledge, but it is slow. We have initiated some of the projects to see how best we can get it done as fast as possible. It is slow. Are we willing to do it? There is a certain consensus that it is necessary, except that the lack of knowledge in terms of these technology, in terms of AI especially, there's a certain level of hesitancy that comes with it. Our conversations to be had, conversations are being had, but we need a certain level of training for judges, then for the lawyers also. The attitude where you find lawyers saying, oh, our work will be taken away, cuts across. In Ghana is the same. There are law firms that don't do anything electronically, paper from beginning to the end. So we are at that point, and I'm sure we'll get to a point where I've had conversations where people ask, why are you advocating this AI thing? Let me say the first thing that I found out, and I think it will be very useful for all of us since we have a variety of people here. I have come to learn that technology is a child of necessity. AI is a child of necessity. All Africans love children. And so if we are going to look at it from that perspective, it will become easy for us to have conversations. In Africa and in Ghana, we say one person gives birth to a child, but not one person brings the child up. It's a whole community. And I'm sure this adage runs in other African countries. Yes. If it does, then can we all agree that AI, like a child, will require all of us as Africans work together to bring it up the way we want to use it. Mm-hmm. An unsupervised child will end up doing a lot of things that will bring embarrassment to us. Mm-hmm. We are supposed to supervise AI and use it in the manner that we want it to be used. How are we going to do that? Our philosophies, which will be the underpinnings of the ethical considerations. How else can we do it? If you give a child too much knowledge or information and he doesn't know where to use it, wherever he goes, he spits it out without any inhibitions. Yes. But for us as a people, if we are able to tailor the information we give, which is the data that we are giving to the tool that we are using, it will become more restricted with the queries that we apply to it. And I believe in all of African societies, these things happen. Hey, whose child are you? Why are you behaving this way? Why didn't you do this? Is this the training? That is AI for us. Finally, we have all agreed AI is a tool. AI is not us. AI cannot become us. What AI does is subject to our acceptance. So if we give AI work to do and it brings it up, we shouldn't just put it out there. Diligence requires that we look over it and then decide how to use it. Thank you very much.
Thank you very much. I like that. And it does take a village to raise a child. So the challenge has been thrown back to us. Now on to Zambia. Justice Kauma, you're a registrar at the Supreme Court of Zambia. First of all, are you paperless? We want to know. And what other strategies or technology have you deployed in the courts, in the Supreme Court specifically? And generally, how do you ensure integrity and security of your systems?
In the judiciary of Zambia, obviously our court structure is we have the superior courts and the subordinate courts. All our courts at the moment are not paperless. So I'll start by saying that we are still very much manual, and that obviously has had a challenge of its own. The first one being that we have huge volumes of paperwork to process and also filing space. Our registries and offices are now full to the point that we now even put containers outside to store extra records. So we have not yet gone paperless. But like Khaled Chief from Malawi stated, Zambia also started going the automation way. Our digital innovation journey started in 2008 when we were privileged to be financed by the Investments Climate Facility for Africa. They gave us some funding and support whereby we started a phased project of going digital. It started with them putting technological gadgets in the courtrooms, starting with the Superior Court, the Supreme Court to start with. We have 2 courtrooms at the Supreme Court of Zambia and of course the major high court stations. So after that phase, the next was how do we now operationalize this technological equipment we have put? It went into creating now an IT unity within the judiciary. So now we can proudly say we have a fully fledged IT department. That also came with the training what we call real-time court reporters. Zambia proudly has real-time court reporters that are able to record proceedings whilst the trial is ongoing. Some judges now don't even write anything. They would rely on the transcript that will be produced at the end of the proceedings. And then, of course, others will still want to take down some notes just to come and cross-check what has been captured. The last phase of that project was to now mean, of course, the other part of the project that was implemented was the creation of electronic records. That went very successfully to a point that today we keep some of the records, not all stations, we have not yet rolled countrywide like Kenya. We have the Supreme Court, Constitutional Court, Court of Appeal, and High Courts with now electronic records. So what we do now, the same manual records, we scan them, keep them on a system, and then we can access them anytime. That has helped us in terms of data retrieval, because we find that I don't know which other jurisdictions face this challenge of a physical file goes missing from the register and we don't know how it has grown legs. So that now helps us quickly retrieve the record, recreate a new file, and then we are good to go. So the last phase of that project was to be with the now electronic filing, including payment of fees and other technological aspects as other jurisdictions have moved. That unfortunately, by 2012, the project couldn't be sustained. And from there, the institution kept fighting for support from cooperating partners and of course the government until 2024 when we finally got a budget line from within our government finance department. And we managed to procure a contract with the Synergy, which we are told installed the similar system in Rwanda and Zimbabwe. And we did see how it is working in those jurisdictions. And right now they are developing it to a point that we are hoping by first quarter of 2026, it can be tested and we start rolling out. So I have to specifically respond to the first part of the discussion. Even all the Superior Courts up to the final level, we have not yet gone paperless, but we are using the electronic record system where it is offline and we're able to access the records. Then in terms of obviously ensuring the integrity and you said
Security.
That's security, the integrity and security of the documents. Obviously, our system is such that because we are not yet fully digital, we still go to the manual records, but then whenever we upload the scanned copies, we make sure that the IT officers assigned verify from the physical records to what is now being uploaded on the system. Amongst one of the serious considerations that we have is if documents that are being processed electronically, even just for physical manual hearings, they must be legible. And we have rules of court at every level that if we are not satisfied, it will not be accepted or admitted, and we'll request the parties to resubmit. So that ensures that the integrity and security of the documents is kept intact. Thank you.
Okay, so you still have physical and virtual hearings.
So so for hearings now actually we have a hybrid of both physical and virtual. So what happens now is if we have a physical hearing, it can be either in chambers or in open court.
Yes.
For virtual, we have not yet equipped the chambers with the facilities, so that is part of the project undergoing now. So we take the judges to the conference room where we have put the screens and the tech equipment. And if I may just mention, at least when it comes to electronic hearings, with the support of UNDP, we have 10 provinces in my country. They have built for us what are dedicated courts for gender-based violence. So those courts now have full equipped tech such that they were targeting victims and children so that they are testifying away from the main or ordinary courtroom, and those are working exceptionally very well.
Okay.
And of course, data is kept and retrieved in a secured manner.
Thank you
Thank
very
you.
much. And just to encourage you, the Honorable Justice William Ouko was once a registrar and now is a judge of the Supreme Court. So I have good wishes for you.
So I'll take it as professor, and I hope by the next law tech I'll be wearing a different title. Thank you.
Exactly. Thank you very much. Now, Honorable Tanui, and you've done a lot of work in terms of automation. Can you give us just a synopsis of, like, is it 3 or 5 years ago, where we were in terms of automation and where we are today? Because I know you've done a lot of work, and just give us a backdrop of the work that you've been doing as registrar automation.
Thank you so much, Maria. This is a very exciting conversation to have. I'll just build on what Justice Lenaula did give us in the morning. He's already given us a very eloquent account of the landscape that has changed for us in the judiciary in Kenya. So specifically to the question that you've asked, where were we 5 years ago? That is in the year 2020. Just before COVID hit all of us globally. So before the year 2020, we had already started piloting the e-filing solution in the commercial and tax division. But we were doing that with a very small team of lawyers and law firms. And we were already building on what would an e-filing account look like. So for us, what we decided to do as a jurisdiction is to build our systems internally. So we haven't gone out to, get a partner or even, buy a system off shelf. We have built ours internally. So before the year 2020 and specifically in the year 2018, we started, defining the process flows and who is the process owner. When you're filing, what happens? It's a lawyer who is filing, it's a litigant who is filing. So all that was done in collaboration with the ICT department. So we had to take through, the ICT developers through the entire legal framework and the process flow. And this is what happens when a lawyer or a litigant is filing. So by the time COVID was hitting, we had already, had a run in the commercial and tax division, and we already had a somewhat, e-filing happening in that particular division. So specifically on 16th of March, I'll not forget when you are told that, we have to close the courts and go home, and yet justice could not, stop. We still had to hear cases, and people still had to file matters. So using that particular system, the Honorable Chief Justice, of course, Justice Maraga, did a practice direction on electronic case management based on what you were doing in the commercial and tax division. And we did roll out e-filing in all courts within Nairobi. So what is e-filing? At that time, we were telling lawyers and litigants, look, you don't have to come to court, you don't have to send your documents through e-filing. From the comfort of your home, from the comfort of your office, you can register a case, you can actually assess that case, and you can pay online, and at the same time, you can get your orders because the judges and the judicial officers will be able to get access of the cases that you have filed on the online system. So we transited from manual case registration, manual filing by payment, going to the bank, queuing, at the bank, and bringing the bank slips to the registries, to the e-filing system where you are assessing for yourself and you're making the payments and you're actually getting a case number. So that is how the e-filing rolled out in courts in Nairobi. And we took 3 years to just ensure that we have refined that process, trained the lawyers, trained the litigants, and also for us, internal stakeholders on how to manage cases that have been filed online. So in the year 2023 is when we decided to take another step and to roll this out to other counties, starting with Mombasa, Kiambu, and by last year, in March 2024, e-filing was rolled out to all court stations across the country. So as we are talking now, there is no way you will interface with the judiciary manually other than through the e-filing system. Of course, there are instances when the system is down. If you have been on the online platform, you can know that we've, had a system downtime from Friday of last week, and there've been a lot of frustrations from litigants on the fact that our system has been down. But what do we do when there's a system downtime? We, of course, build the resilience of our systems, but even as we do that, look at the backup plans that we have. We give alternative ways of filing. So we revert back to what we had. And by this time, we are saying, look, use the email addresses that we were using during COVID, file your matters through email. We will be able to get those documents and we will be able to assess them internally, give you the invoices, you make your payments, and still the judges will use now the case tracking system, which is internally facing, to be able to process those particular documents. So that is in respect to filing. So from the time that you initiate a case to conclusion, we manage that through the e-filing system. And for us internally, we manage it through the case tracking system. It is the same system. It is just that e-filing is, external facing, and the case tracking system is internal facing. But at the court level now, when this matter is ready to be heard, all our matters, 90% of our cases are proceeding online. Every judge, every judicial officer has been given an online account to manage their court. So what do? The online court sessions mimic exactly what happens in physical courts, where they are public. So if you go to our cause list portal and you get the cause list of any judge or judicial officer, you will see that they also have a link. That link is public facing. Anyone across the world, anyone can join that particular court and follow the proceedings online. So we have also managed to transit the hearings in court to the online platform. We are still lagging behind, of course, in the criminal cases, and because of the many actors in the justice sector. So the criminal cases, which takes about, another maybe 40%. So 90% civil cases are proceeding online, but criminal cases, maybe we are only at 30% now because of the other actors in the justice sector, which we are still capacitating. And that is what Justice Lenaola did allude to in the morning. Thank you.
Thank you, and I want to stay with you because I want to come back this way because we also have another panel with the Francophone judges. I just want to ask you, because you took the words out of my mouth, when you were talking about the courts being public, isn't there for you a concern, or has it been raised by the public, that because these court proceedings are public, but some of the nature of the proceedings tend to then proceed get into privacy issues? How do you handle that as a judiciary? What safeguards have you put in place for litigants who might be concerned that people are logging in to listen to their case just for entertainment or gossip value?
Thank you, Maria, and I'm sure the honorable judges will be able to contribute to what I will say. So we have been very specific, especially when you're dealing with children cases or divorce matters. Those particular hearings are actually held privately. So even though the link to that particular court is public, in regard to children cases, the link is sent only to the parties and to the advocates that are in that particular case. So you will not get a public shared link in respect to children matters or matters that are dealing with family issues. Those particular links are only sent to the litigants that are involved in that case. Thank you.
Final words for us?
Final words, I think this is a good conversation that we are having. We cannot run away from technology. for us now and for everybody else outside even the judiciary is how do we capacitate all of us to be able to be able to engage in such a conversation, and also just to to ensure that we, as we embrace technology, we don't also digitally exclude others. So for me, is just to ensure that we are all capacitated and that we also take a step wherever we are in our corners to capacitate others. Thank you.
Okay, thank you. Honorable Kauma, I was just about to call you Justice Kauma. What would you say the future looks like for the courts in Zambia in terms of now that you're going to roll out, I'm assuming you're going to automate the courts fully. What for you would be the concerns when it comes to data privacy? And how do you feel they will be addressed? Do you have the legislation in place to address those issues that might arise?
Okay, thank you so much. So obviously, before I can even talk about the concern of data privacy, our first challenge would be obviously the infrastructure, the digital infrastructure. Our country obviously is still not yet there when it comes to internet. So you find that even that, yes, we are saying, let's see how it can go. As everyone is saying in the room, we cannot remain behind. Technology has come to stay. We must run with it. And obviously, there is also AI, which you slowly, even as we are discussing every time meeting about what is it about, how do we embrace it. But so, as we roll out our system, we have been consulting obviously various stakeholders, including the Royal Station of Zambia. The president is there, can confirm. We are coming up with the rules that will be responsible for managing the case management, the electronic case management system. And obviously, currently, we still have data privacy laws. I can't get it off my head now. We have a Data Protection Act, including several other, and recently we even amended cyber laws. So we have, I think, enough safeguards. And when it comes to, obviously, data integrity, privacy, we have a very vibrant Royal Association of Zambia, including the civil society, human rights groups. And I think when it comes to legislative changes, if there will be any concerns or gaps that will come, the government will be responsive quickly so that we do not trample on any person. And just as my last comment, the Honorable Chief Justice has actually right now opened up doors to public streaming of live streaming of certain proceedings of public interest. We had our first case of eligibility of the former president to recontest future elections. It was allowed, of course, it was at judgment stage. It was able, we were able to broadcast it and people followed it. We are still trying to come up with more rules and guidelines so that we fine tune the space so that it takes care of various people's interests. There is one case which we almost allowed to go, it is a criminal trial, but after some public outcry, the Chief Justice has to quickly withdraw his authority to have the proceedings broadcast live. So in short, we have currently enough legal provisions in terms of that integrity of the evidence and the protection of privacy rights. But where we will see a gap, I'm sure all stakeholders will come on board to make sure that we address that. Thank you.
Thank you. Honorable Ablo, and what for you is a successful digital infrastructure implementation that has happened in Ghana that you would speak from a personal experience as a judge? What is the infrastructure that's been deployed that's the most successful for you?
One would be the judicial service portal, an online system where case reporting was real and on time. A few instances where we have had online hearings. In criminal cases, it's a bit difficult because you will need the express mandate of the Chief Justice authorizing that you do so. In several cases, we have amended our civil procedure rules to incorporate online hearings. So on legal vacations, for instance, so after 31st July to 1st of October, we are on legal vacation. All judges who are sitting during the vacation are going to sit using the online system. The online system is going to be open to all who have access to the link. In these instances also, cases that are sensitive in terms of national security, safety of the children, confidentiality of marriage, definitely out, except for the parties who are involved. So in that arena, yes, the e-justice system, when they started, was, I'd say, in all the areas where they were piloted, successful until the issues of upgrade, sustainability over time came up. And the little issues of, let me say, adaptability to our circumstances were not available. There have been some private initiatives where, in terms of the case reporting, I think we need to commend them. The very famous one we have is one we call Dennis Law.
Okay.
Every information, real-time reporting is available. Fortunately, we have had one which covers the West African sub-region, judicial law, Nigeria, Ghana, and then the other English-speaking countries. So in terms of reporting, these ones are available. The concern, digital infrastructure, data protection, cyber resilience. And I was happy when the Honorable Chief Justice was talking about the incidents that we have had. Cyber resilience is always on the table.
Yeah.
Because one glitch and everything is turned upside down. So the conversation has to be all-encompassing. And as much as we are going to expand, everybody in that chain must be part of the conversation. Let me take the opportunity to now tell Lawyers Hub, bravo for what you have done. I haven't seen this anywhere where everybody in that industry is part of the conversation. It's make it easier for me to have conversations with people outside than I would have with people in Ghana.
Yes.
I have been a panel member on a few of the online programs. Last year, I was a panel member. And the conversation is easy because this platform exists.
Yes.
I talk to my fellow judges and, Charlie, this thing makes you lazy. Meanwhile, the amount of thinking and diligence that is required makes you rather sharper.
Yeah.
So, thank you very much for the opportunity. And I believe we can continue. Let this community remain. We are the African village that we need to make this work.
Absolutely.
Thank you.
Thank you so much, Justice Ablo. Honorable Kendago, what do you feel about the adoption of technology? We say that it's a tool, it's an enabler, but do you find from a personal perspective that sometimes it's too much? Because now that we are automating, now that there's transcription, we talked about making sure you're finishing your call over, then you're able to come. Are we increasing the workload with technology? Are we making it lighter? Is there an ethical issue for you when it comes to how far do we go with this adoption of technology in terms of your time as a judicial officer?
Thank you, Maria. Of course, when we started off, I think way back, like what Honorable Tanui has mentioned about the journey, and I think a general expectation whenever there's something new that is introduced, there's always the fear about what to expect, what is going to happen. And so just like any other individual, the issue of culture change, again, I think really robs when you're looking at it forward-looking. So there was the scare with the introduction of technology about the expectation as a judge, a judicial officer, that you'll be typing your proceedings, you'll be typing your judgment, that you will have to be doing the online research. And when it started off, there was that scare. But over time, I think now very few of our judges in Kenya would fall back to an instance where you would handwrite your judgment and ruling. And I think our partners will also agree with us that it's now taking a shorter time with even the requests for typed proceedings. We have some courts that are currently typing their proceedings as we are going on, and very admirable, and hoping that we'd all get there. So of course, with that fear, but over time now you realize that it is easier for you to have a decision that you're typing yourself as opposed to a handwritten, and then somebody types, it comes back to you, and you spend longer time, much difficult to edit it back, as opposed to if you were just preparing the decision. The other fear, of course, about technology is the general expectation that maybe what is what you are doing right. And then, of course, the other fear that comes with it is you look at it more of just beyond us as judges and the judicial officers, is the work of the support team that we have, the legal researchers, the secretaries, the court assistants. But as opposed to the fear that would come in that it would lead to an instance where we no longer need those services, it has actually made it very easier for us to collaborate across the various actors that we are supporting one another. So you'd find that it makes work easier for me as a judge, it makes work easier for the secretaries, it makes work easier for even the court assistants, and it also improves not just the quantity, because sometimes I think you are driven more to look at it in terms of the generation of more, the conclusion of more. But the other very positive bit is that it has also improved on the quality of the work that we are doing.
Oh,
Thank you. And I think for me, as a parting shot,
Yes.
is the future is here, and it's very interesting that we are transiting together. So I'm looking forward to more collaborations, and just like Judge has mentioned here, let's keep the community going.
Thank you, Honorable Kenda Gore. Honorable Justice Visram, I want to ask you about something that Honorable Justice Lenaola spoke about, and this is about asking us to be wary of how we use AI because it hallucinates. Now, as a judge reading our submissions, how do you know that what has been submitted to you is factual? So do you have a tool for checking? And number two, what would you consider in terms of the thought that AI could write judgments?
I think the idea is that you should cross-check that the law that AI has generated is one, applicable to the argument you're making, and second, that it's actually in existence. We see on several occasions that parties produce wonderful quotations and authorities which in fact don't exist. And that's the problem, that these are hallucinations on the part of AI to support an argument that you're making. So my advice would be cross-check. On our side, what we do is we do cross-check. So when you have a particular authority in support of a case, we actually pull up the authority from Kenya law and we read through it and we make sure that it actually says what it is that you said it says. And often we find that it doesn't exist. In terms of AI being able to write judgments, yes, there's huge potential for AI to generate opinions or drafts. And I think that AI, again, must be used as a tool for improvement, not a replacement for judgment. And the reason being is that as judges, we think about more than simply the law. We exercise discretion. We look to see what the equitable principles are in relation to that case. We are not exercising compassion, but we look for reason and we look for mitigating circumstances. So as judges, when we exercise all of those elements together, there's a human aspect. Often there's an ethical aspect, and sometimes there's an equitable aspect. So we look to see if the applicant has come to the court with clean hands. So there are so many areas that I think AI cannot replace human nature and human judgment in respect of. I think one of the One of the important things that we can do, however, is get better training in this area. And I said this before, but I'll come back to it very briefly. There are conventions that Kenya has just adopted and signed up to, like the Budapest Convention, for example. The Budapest Convention provides a positive obligation on the part of the state to collaborate with other states in terms of cybercrimes, in terms of preserving evidence, in terms of collaboration when it comes to evidence that's been used in cybercrimes. So I think this is an area where if a state places an obligation on judicial officers to carry out certain duties, there must be a corresponding obligation to train us in relation to those areas. And this is where I think there's a need for stakeholder engagement to bring the experts and the judiciary together and say, how can we learn from one another? How can we both be better at doing our jobs and ensuring that AI remains a useful tool as opposed to a substitute for the work that we do? I'll stop there. Thank you.
Thank you very much, Justice Visram. Justice Aisha, just going with the flow of training, I want you to comment about legal training for our students. And I know it was asked yesterday to the bar leaders, but I just want to hear from a practical perspective, thinking about how you were trained or how we were trained as lawyers, and now what we have to face. In Kenya, we say, kwa ground vitu ni different. Things are different when you come to practicability. What would you recommend, having been a member of the bar and now sitting at the bench, is the type of training we need to take our young people through?
Last month, I was a part of the team from the judiciary of Tanzania and the what do we call it? The Judicial Education Institution of Tanzania and GIZ in developing a training manual for legal research, and it catered across the board because of the recent developments in the legal profession that we are seeing, especially which are technological related. So the training manual for legal research caters for judges, magistrates, and we have other training manuals which cater for the legal profession, which are advocates, lawyers, and paralegal. And the other one caters to the universities, which are teaching law. So the judiciary, we had to spearhead this because we had seen the gap in the legal education system in Tanzania. Before I became a judge, I was a member of the Council for Legal Education, and we inspected most of the universities in Tanzania, and we had seen the knowledge gap with the students and the upcoming lawyers who were enrolled as advocates. As the situation in Kenya, in Tanzania as well, once you're admitted as an advocate, you can immediately, on the same day, go to court and prosecute your case. So with the judicial training manual, we have tried to introduce a chapter on the use of AI tools so that we could bring everybody else on board. Because the judiciary of Tanzania has really advanced in the electronic case management system. We are full digitalized in all our courts, except for the primal courts. But from the magistrate courts to the Court of Appeal, we are all using the electronic case management system. So we saw there was a need to include students and paralegal on the tech-related issues, and we have recommended specific AI tools which can be used by paralegals and new advocates who are admitted as advocates. Thank you.
Thank you, Justice Aisha. Justice Zion, what would you say is a tool that's working for you as a judicial officer? What would you recommend? What would you avoid?
What is a tool that's working for me? I'm using a lot of tools, so I'm not sure what
Your best.
my best.
Okay, top three.
I can't say best because I'm using a number, and I use them for different reasons.
Yes.
Because of different issues.
Yes.
I use ChatGPT, but I stopped using the free one for a while. I pay for it personally for reasons. I use Claude AI, and then I use the normal ones that you have, the Pilot, the Gemini. So I use all those because Gemini at least is part of the system. I pay for it with Word and all those things that I've paid for and with the internet. But what I could say about what can you avoid? Free things are nice. Yes? Everybody loves free things, but they have limits. And that's where the issue is coming from. All the complaints we've heard about, hallucinations, they're coming because we're using free software that already has a disclaimer that says it will not go beyond a certain point. It actually says it. So as lawyers, we already know what a disclaimer entails. So because we're lawyers and we know what it entails, it means whatever we're using it for will have limitations unless you check it. And that's why the disclaimer is there. They're saying we're not liable. As lawyers, we like liability. So if you pay for it, at least the liability is not on you. It's on them because you've paid for a service. So yes, so that would be my issue, that the free ones are good, but they have limitations. Now, as lawyers, you talk about fees. With fees must pay for the tools that we use. And that's why AI is good in its very essence, that it helps us to do all that. But the free stuff has limitations. And even for us as judges, it also means that we have a major challenge because we can't also use the free stuff because it will have its own limitations, which means as judiciaries, we must invest. We cannot keep saying, we're investing in these tools and only pay for 5 people. You have 1,000 users, it means you must pay for 1,000 users. Correct. And you must pay for 1,000 users every time it's due. You can't pay now, and the government doesn't give you money to pay next year. So the sustainability of funding for technology and access to justice with that space requires that we invest. And the investment is not today only. It is a continuous investment. And I think that's where my challenge is as a judicial officer, that it's constantly being on my pocket to pay for these tools in order to be able to be effective.
Efficient, yes.
As opposed to it being a judiciary-based thing, when ultimately I'm doing this for the judiciary. But you realize you have to be efficient for yourself, so you pay for it. But you can only pay for so many. You can't pay for all.
Yeah.
And that's where the limitation comes in as well. So my final words?
Yes.
I believe in the concept that we as judiciaries need to be responsive and responsive to the needs of everybody. AI helps us to do that because it also helps reach out to the people we actually never consider. We talk about chatbots. We talk about the ability for AI to put up a whole affidavit or sworn statement. There are people who are not able to afford a lawyer or a paralegal, but they can afford to use a chatbot on their phone or something developed on their phone to actually bring their case in. because the system would have said, you would have prompted it for that. I believe in the concept that justice must be for all. And if we're going to use AI, it must be used for all, including the people that we least consider, even with the concept of AI or the concept of technology. So that's what I would say. Thank you.
Thank you very much. And with that wonderful closing remark, please help me appreciate my lovely panel, Justice Zion, Justice Aisha, Justice Visram, Justice Kendagor, Justice Ablor, Honorable Kauma, and Honorable Tanui. Thank you very much. I'll invite you to come forward for a quick photo.
Okay, photographs are ready. Yeah. And maybe the audience can help them smile by giving them all a round of applause for blessing the stage. Yep.